Hello, everybody. I am Leher Jain, a second year law student at the National Law School, Bangalore. And on behalf of the CLAT Tutor legal team, I'm here to discuss an extremely topical topic. We will be discussing the writ petition, which has been filed against WhatsApp and Facebook for the issue of infringement of privacy. Now, the name of this case is Karmanya Singh Sareen versus Union of India. The Supreme Court has set up a three-judge bench comprising of Justice A.S. Bopanna, Sharad Bobde, and V. Ramasubramaniam to hear this matter. This writ petition was filed in 2016. Now, a very basic background in facts which led up to this case was that, as we all know, WhatsApp was in 2014 bought by Facebook. Now, 2 years after that, WhatsApp announced a change in their privacy policy. Now, what this change did was it permitted WhatsApp to share data with Facebook, and which is now its parent company, and all of the other group companies for the purposes of ad campaigns and market companies. Now, what WhatsApp essentially does with this data is that it transfers it to Facebook and other connected companies, which then bundle up this very personal data and sell it to a lot of commercial companies and marketing agencies to then use it for its targeting ad campaigns. This has been challenged as being violative of the right to privacy under the constitution of this country. The petitioners in this case argue that this sharing of private data, now WhatsApp collects data such as the messages that people have, people's phone numbers, and people's private information. This constitutes private data, and sharing of this with other users such as Facebook and other companies threatens the right to privacy of its users. Now, this case was initially placed before the Delhi High Court. The Delhi High Court very interestingly actually rejected the petition. It granted only one kind of relief to the petitioners, wherein it said that WhatsApp would delete the data of the users who had deleted their application before 2016. However, it completely accepted WhatsApp's new privacy policy, and it said that under this new policy, WhatsApp was free to share its data with Facebook. It also held that people who do not want WhatsApp to collect their personal information should not even use WhatsApp in the first place. And because of this reason, an SLP was filed in the Supreme Court thereafter. Now, the issues formed by the Supreme Court are really threefold. The first issue is whether WhatsApp's privacy policy is a violation of the right to privacy, which has been recognized by the Constitution. Secondly, is whether there is a right under this right to privacy that users should be able to have an opt-out mechanism wherein they can choose to either share their data with Facebook or not, while still being able to use the application on its whole. So the real question is whether WhatsApp is obligated to provide a specific option of not to share data with Facebook. And the third is whether is really revolving around consent, and whether what should be the manner of seeking this consent from its users, and is the correct way of asking consent in the form of extremely long and small worded privacy policies, or should there be another way of seeking consent? Now, the only rule which is extremely relevant for us to be discussing is Article 21 of the Constitution, which says that no person shall be deprived of his or her life or personal liberty, except according to the procedure established by law. This is because it was under this article that the Supreme Court recognized the right to privacy. Now, in the case of K.S. Puttaswamy versus Union of India, it is for the first time that the Supreme Court recognized that the right to privacy is a fundamental right under Part 3 of the Constitution. Now, what do we mean by privacy? Privacy basically means, in colloquial terms, a private space for a person, or the right to be left alone. Now, the court did an extremely interesting analysis in this case, wherein the court first recognized that dignity is an extremely important and inseparable part of the right to life and liberty. Now, this dignity has not explicitly been mentioned as a right under the Constitution, but it finds expression in the preamble itself, which is ensured by fraternity. This dignity was found to be a very important part of Article 21. Now, the court tied up this aspect of dignity with the aspect of privacy. So, the court really did a layered analysis to connect privacy to Article 21, wherein it found privacy to be an essential aspect of dignity, and thereafter the right to life and liberty to be an essential part of dignity itself. Now, another important aspect that the court must consider in this case is the committee formed by Justice B.N. Sri Krishna. And this committee then recommended a law which has now been turned into the Personal Data Protection Bill of 2019. Now, this bill is still standing in front of the standing committee and has not been passed by the parliament as of yet. Now, there are four aspects on which this committee submitted its report and around which the Personal Data Protection Bill revolves. First is the importance of individual consent, which really says that consent is at the centerpiece of everything revolving around data sharing and data protection, which is that people should have the right to give consent to how their data is going to be used, how it's going to be processed, how it's going to be shared, and how it's going to be stored. The second important part of consent itself is the right to be forgotten, which essentially means that you can take back your consent at any point of time. Individuals are free to limit the amount of data they want to share, to delete the amount of data at any point of time, or to disclose or not disclose any form of personal information on the internet. Thirdly, it is the setting up of data protection authorities. Now, the law will oversee the setting up of these authorities, which is essentially going to be an independent regulatory body, which is going to enforce and implement this law. And lastly is what personal data means itself. Now, the law will cover the processing and the storing of personal data, and it covers both public and private companies, which is basically the government, along with private big corporations such as Facebook, Instagram, and Twitter. It must be noted that this case has not yet been decided by the Supreme Court and is still being heard by the same. It must be noted that this case has still not been decided by the Supreme Court and is still being heard by the same. And hence, we will have to wait and see how the Supreme Court takes into consideration Article 21, the judgment of K.S. Puttaswamy and the right to privacy, along with B.N. Sri Krishna Committee's report and the bill which has not been passed yet. Thank you so much for watching. If you have any further queries, you can feel free to mail us, and please do leave your feedbacks in the comment section. Thank you.